Hey everyone, today we're going to pull back the curtain on something we see all the time in movies, but don't always understand in real life. The journey of an accused person through the Canadian criminal justice system. We're going to follow that path right from the moment a charge is laid, all the way to a potential verdict. So, yeah, let's get right into it.
So what actually happens after someone is arrested in Canada? It's so much more than just courtroom drama. It's this structured, incredibly complex journey with these critical turning points that can literally change a person's life forever. And that's exactly what we're going to do here. Walk through that journey step by step.
All right, so our journey starts right here at stage 1, the offense, the arrest, and the huge question of bail. This is the foundation. Seriously, everything that happens from this point on is shaped by the decisions that get made in this very first phase.
Okay, so the very first thing you have to understand is that not all crimes are treated the same. In Canada, they're sorted into 3 main buckets. On one end, you've got your summary conviction offenses. These are the least serious things. On the complete opposite end, you have the most serious indictable offenses, like murder or robbery. And then right in the middle are these things called hybrid offenses, which, well, they can go either way. And this isn't just a label, it dictates the court, the entire procedure, and the absolute maximum penalty.
This brings us to a really pivotal moment for those hybrid offenses, something called the Crown election. Now, when we say the Crown, we're talking about the government prosecutor. For these middle ground offenses, the prosecutor gets to choose. They look at all the details, how serious was the act, does the accused have a record, and they decide which path to take. And you can see why this is a huge deal. That one single decision can be the difference between facing a max penalty of a couple of years or possibly life in prison.
So once a person's charged, the next massive question is bail. And this is so important. It's a fundamental right in Canada, written right into our Charter of Rights and Freedoms. Section 11E says it loud and clear. You have the right not to be denied reasonable bail without a very, very good reason. So the default position, the starting point of our justice system, is release, not keeping someone locked up before their trial.
So, how does a court figure out the terms of that release? Well, they use what's called the ladder principle, which you can see laid out here. The court has to start on the very bottom rung, the least restrictive option possible, like just a simple promise to show up to court. For them to climb that ladder to stricter conditions, the Crown has to prove why it's necessary. You can't just jump to the top and demand a surety. It has to be justified every single step of the way.
But of course, bail isn't a 100% guarantee. It can be denied, but only on 3 very specific grounds. The first one, the most common, is just to make sure the accused actually comes back for their court date, that they're not a flight risk. The second is to protect the public from any further crime. And the third, which is a bit more abstract, is all about maintaining the public's confidence in the justice system. And remember, the burden is always on the Crown to prove one of these grounds actually exists.
Okay, so let's say bail is sorted out. What's next? Well, now the accused has to navigate the court system itself. This means figuring out which court is going to hear the case, and if it's a serious charge, how on earth a jury gets picked.
A really good way to think about the court system is like a staircase. Down at the bottom, you have the provincial courts. That's where the vast majority of criminal cases are handled. But as cases get more serious, or if a decision gets appealed, they start moving up the stairs to the superior courts, then the courts of appeal, and finally, right at the very top, the Supreme Court of Canada.
And here are some perfect examples to make it concrete. A charge like theft under $5,000, that's going to be handled in provincial court on that lower step. But one of the most serious offenses out there, like murder, well, that automatically goes to the higher level superior court, and it's almost always going to be tried by a judge and a jury. And speaking of juries, let's talk about how they're picked, because this has changed in a really big way. For a very long time in Canada, lawyers had this tool called a peremptory challenge. It basically let them reject a certain number of potential jurors without having to say why. It was a purely strategic move, a way to try and shape a jury that you thought would be most sympathetic to your side.
But this tool came under a massive microscope. This quote here points to a case that really brought the whole issue to a boiling point nationwide. In the trial of Gerald Stanley for the death of Colton Boschi, the defense used its peremptory challenges to remove every single potential juror who appeared to be Indigenous. This led to an apparently all-white jury, which, as you can imagine, sparked a huge public outcry about fairness and representation in our justice system.
So, what happened? Well, Parliament stepped in, and in 2019, they got rid of peremptory challenges completely. The main reason was to fight systemic racism in jury selection. But it's a complicated issue. Some critics pointed out that this also took away a tool that defense lawyers for, say, a racialized client could have used to try and get more diversity on a jury. It just goes to show how tricky it is to build a truly representative jury, and people are still debating whether this change really solved the problem.
And that brings us to the main event, the climax of this whole journey, the trial itself. This is where the evidence comes out, the arguments are made, and the core principles of Canadian justice are really put to the test.
Right at the heart of every single criminal trial is this phrase, beyond a reasonable doubt. This is the highest possible standard of proof in our legal system. We're not talking about being 51% sure. That's for civil cases. This is much, much higher. As it says right here, if a judge or a jury thinks the accused is only probably guilty or likely guilty, they have a legal duty to find them not guilty. It's an incredibly powerful protection. Now, in a jury trial, there's a really clear division of labor. The judge is the trier of law. Think of them as the legal referee. They make the calls on what evidence is allowed in and explain all the relevant laws. The jury, on the other hand, is the trier of fact. Their only job is to listen to the evidence, figure out what they believe actually happened, and then take the law, as the judge explained it, and apply it to those facts to come up with a verdict.
The trial itself follows a pretty logical order. The Crown always goes first, they get up and present all their evidence and call their witnesses. Then, the defense gets to cross-examine every single one of those witnesses before they decide whether to present their own case. After all the evidence is in, the judge gives their final instructions, that's called the charge, to the jury, and then the jury goes off into a private room to deliberate. And let's not forget the single most important idea that runs through this entire process, the presumption of innocence. An accused person never, ever has to prove that they're innocent. They don't even have to say a word or present a defense. The burden is always 100% on the Crown to prove guilt beyond a reasonable doubt.
And that brings us to the final stage of our journey. This is all about what happens after the verdict is read, the right to appeal, and the constitutional rights that have been protecting the accused from the very beginning.
Everything we have talked about is anchored right here in the Canadian Charter of Rights and Freedoms. Section 11, which you can see on the slide, is the absolute bedrock. It guarantees the rights we've already covered, like being presumed innocent and having the right to reasonable bail, but also other crucial ones, like the right to be tried within a reasonable amount of time. And these are not just suggestions, they are constitutional guarantees.
So what happens if someone is found guilty? Well, they can appeal, but it's so important to understand what an appeal actually is. It is not a do-over. It's not a new trial. The appeal court doesn't call any witnesses or listen to the evidence again. Instead, a panel of judges just reads the transcript of the trial to see if the trial judge made a major legal mistake that could have affected the outcome. It's a review of the law, not a retrial of the facts.
And so, that's where our journey ends. We've walked through a system that's built on centuries of core principles: presumed innocence, proof beyond a reasonable doubt, fundamental rights. It's an incredibly complex, rule-bound process, and it's all designed to ensure fairness. But I guess the final question we're left with is this: does it truly guarantee justice for everyone involved? That is something worth thinking about. Thanks for joining me.